Hi, everyone. It is great to be here at Rightscon, at least remotely. And thank you so much to the organizers for putting on such a fantastic agenda and set of sessions. My name is Uttara Sivaram. I work at Uber as their head of privacy and security policy. For the past few years, I've been investigating the intersection of government access to data, privacy, security, and data standards that drive effective public policy. Today, I'm joined by four distinguished panelists to look at this issue from a few different angles, and I'm pleased to introduce them. We have Greg Nojeim, a senior counsel and director of the Freedom, Security, and Technology Project at the Center for Democracy and Technology, or CDT. CDT is a nonprofit public policy organization dedicated to keeping the internet open, innovative, and free. He specializes in protecting privacy in the digital age from intrusion by the government and is a recognized expert on US surveillance law and on cross-border data demands for law enforcement. Our next panelist is Samm Sacks, a cyber policy fellow at New America and a senior fellow at Yale Law School's Paul Tsai China Center. Her research examines China's information and communications technology policies with a focus on China's cybersecurity regime and the geopolitics of data privacy and cross-border data flows. We have Jake Snow, a technology and civil liberties attorney at the ACLU of Northern California, focused on consumer privacy, government surveillance, algorithmic fairness, and the preservation of free speech online. Jake works in the courts and the legislature to protect people's privacy rights from intrusion by both companies and the government. And finally, we have Paola Galvez, who is the head of policy at Niubox and passionate about shaping a better regulatory framework for the Peruvian digital economy. Paola began her career in Microsoft, and she has 5 years of experience focused on privacy, cybersecurity, and the digital economy. Thank you so much to all of you for being here. So today we'll dive into the issue of surveillance and the use of individualized data for automated or algorithmic regulation. Now, I thought today's title was pretty dramatic until I saw all the other panels scheduled for today, but this is an incredibly important topic given the current state of the world. As you can imagine, my interest lies in the mobility space, where there's a growing appetite among governments around the world to collect more data about where individuals are going and how they're getting there. In some cases, this is to create a more harmonious transportation sector. In others, to track individuals and enforce the law. A lot of this data is from the increasing number of sensors in the public right-of-way, things like red light cameras and automated license plate readers, which have caused a lot of concern from the privacy and civil liberties community. I recently read about a transportation department using facial recognition technology to identify speeding drivers, which is interesting. But I'd be remiss not to mention that a lot of this data is generated and consumed by private industry, which has led to escalating tension between the public and private sector, particularly consumer-facing companies who need to manage the trade-off between protecting their users' data and complying with government demands for data. There's an added challenge when it comes to location and mobility data, which is notoriously difficult and almost impossible to anonymize. An individual's location traces are so unique. So with very little effort, they can be reverse engineered to reveal who took that trip and why. This is a big challenge for a company like Uber, who gets asked to share trip data with regulators around the world. That said, it's really important for policymakers to have access to quality and accurate data. We all want great data-driven policy governing our cities, and there are legitimate, urgent uses of data for community safety and national security, particularly during this time. So in today's discussion, I'd like to dive into the different legal and policy approaches to data and identify opportunities for both the private and public sector to unlock the value of mobility data and location data without compromising privacy or fundamental rights. My first question is around Robin. This is for all the panelists. After about a 30-minute Q&A or 30-minute panel discussion, I'll open it up for Q&A. So yeah, the first question really gets to the heart of the issue. What are the primary risks of increasing surveillance in public spaces, and what are the challenges of using that data for policy and regulation? Paola, I'd love to start with you and get your thoughts.
Thank you so much, Uttara. Greetings from Lima. It's a pleasure to join you in this very interesting discussion and relevant topic that Uttara mentioned just now. You know that in Peru, there was a state working group led by the Ministry of Defense, which had the power to compel telecommunications operators to provide the geolocation obtained through cell towers of anyone who reported symptoms of coronavirus. All the collected information was processed in a hotspot map in order to have up-to-date data. The interesting fact about this is that during the press release of the hotspot map initiative, the Ministry of Defense showed a screen where the website access link was visible, as well as the usernames. The local NGO Hiperderecho noticed this, and by performing a very simple access test using as password the same users, they were able to access the data. Then I ask you, was the government up to the task? I mean, the government stored highly sensitive data. Mobility data is sensitive and must be handled responsibly. After hearing this anecdote, I'm sure you have no doubt that, in my opinion, the primary risk of increasing surveillance in public spaces and one of the biggest challenges of using that data for policy and regulation is that even though there is no technical capacity of the government, they are jumping on collecting large volumes of data. Peru is not the only case study. In Ecuador, for example, there's been an issue authorizing the government to use data from satellite and mobile telephone platforms to monitor people who tested positive for the virus. Israel, across the globe, authorized the security service to collect and process location data from telcos without user consent. I mean, the increasing trend on location collection could lead to human rights abuses if they are not trained to handle large volumes of data, nor equipped with effective safeguards to protect privacy. Sadly, we're not seeing that capacity at the government level yet. A data-driven policy means nothing without the skills and technical capacity to execute it. As a member of the CADE Digital Committee in Peru, we're working on an initiative to offer capacity building training for policymakers in an attempt to facilitate the Peruvian data transformation.
Thanks so much, Paola. Jake, I'd love to turn it to you.
Thanks a lot. It's great to be here. I for risks of collecting this kind of information, whether it's location information that might be in the hands of private companies. First, harm to people, and I think in we often don't identify or talk about the fact that these are not rows in a spreadsheet. These are people's actions in the real world, and that has a real individuals. I mean, when we talk about automated license plate readers being used to target and deport immigrants, those are families being torn apart. Those are people who are being physically harmed. And then you also have potentially tracking and manipulation of people through algorithms on a large scale. I mean, when governments are able to monitor and control, they could say that people aren't allowed certain modes of transit to get to a political protest, or they couldn't use to a medical clinic for necessary treatment. And that's in many ways the flip side of the ability that private companies would have to do that same kind of control and manipulation. Company can use to maximize profit and deprive workers of pay. That information in the hands of government has similar risks. There's also the possibility of capturing value from that information that isn't currently realized. And just one example of that might be to take a store of location information and then use that to build a tool that could be sold for profit, a traffic management tool, a self-driving car. Those kinds of things can use the resources of location data without having any knowledge of that, and can be used to capture value in that way. I think it's worth also highlighting the fact that these harms don't fall equally on all people. When the government has the ability to track and monitor and identify people who go to protests against police violence, that harm disproportionately falls on Black people in the United States. When the government has the ability to identify, track, locate, and deport immigrants, that harm falls on Latinx community in the United States. And so these are not risks that we all experience. They are risks often that are experienced by the most vulnerable communities. And so that's something that I think needs to be part of the conversation as well. Thanks.
Thanks, Jake. That was very well said. Sam, I'd love to turn it to you and hear about your thoughts on some of the risks and challenges, particularly in China, which I'm sure there are a lot of differences, but also similarities to what Jake is talking about how the impact, the disparate impact can be pretty severe.
And it has the most sophisticated surveillance system in the world. And I think that's been well documented. Something that I think is less well documented outside of China is the internal debate and the sort of push and pull that happens particularly between Chinese tech platforms and the government over access to data. And I think that I've been tracking the build out of China's data protection system for the past 2 years or so. And just very briefly, the way that I think about it is there's a split identity when it comes to privacy in China. Many might be surprised to hear that there are rules and standards in place around how platforms collect, retain, share, process user data. And the government's been really cracking down on this in China, but it's really consumer privacy. It's sort of a way to keep companies who are holding vast troves of data in China in check, where there's a very separate track when it comes to what the government is able to do with data in China. And I want to highlight one example from the mobility space in particular, given Uttara's focus. 2 years ago, Didi is the sort of Uber of China, China's big ride-hailing platform. 2 years ago, there were passengers that were murdered while using Didi, and the government opened an investigation, and as part of this, required that Didi turn over data on the routes, GPS data, the passengers, the drivers, and Didi actually refused to comply with the requests, and there were three separate requests that were made. And it wasn't until the third time that they actually did comply. And the story goes that apparently Didi representatives showed up at the police station with hand-printed boxes of paper saying, okay, you wanted the data, here it is. And it was completely unstructured, unformatted, it wasn't usable. And there was a big debate in Chinese social media. Should Didi comply with this? And the cybersecurity law, which took effect in 2017, has provisions around consent to collect data. And so there were legal scholars in China arguing, well, if Didi complies, this is potentially in violation of China's cybersecurity law. It turned out that Didi had been flouting a regulation requiring real-time data access monitoring to one of the transportation authorities. So this became a very interesting public debate, and I think still highlights that even though, yes, in China, the government has vast authority without oversight mechanisms, enforcement mechanisms to demand that companies turn over data, there's much more of a sort of push-pull and sort of debate within that system that is often recognized from the outside. So just leave it at there. But I think there's some interesting takeaways as we think about some of these issues in the US context too.
That is super interesting, and I appreciate the example about Didi. That was super interesting at the time. Greg, I'd love if you could round us out. What are your thoughts about the primary risks, the biggest risks that are posed by this kind of expanding trend of surveillance?
Thanks, Uttara, and it's a pleasure to be here. Thanks to the other speakers. Thanks to Access for putting on this conference remotely. It's a weird time, and I'm really glad folks could join us. I'm speaking from Washington, D.C., and I think, Uttara, that the big issue here is that location information can be very revealing about what a person's activities are. And you can infer a lot from where a person goes, particularly if you know precisely where they started and where they ended, about what their activities are. And here in the US, we had a recent Supreme Court case, the Carpenter case, where the court actually said, hey, this location data can reveal things like your religious affiliation, whether you're going to an abortion clinic, very sensitive information. And we need to protect it at the highest level in US law. And it imposed what we call a warrant requirement for compelled disclosure of a significant amount, 7 days or more, of stored location information. In the context of the mobility world, what we're seeing is that a lot of cities, and this is a global issue, are demanding mobility data that reveals location right down to the individual trip, and sometimes even in real time. This can be very detrimental to the privacy of the people to whom that data pertains. And often these demands are being placed on companies to make these disclosures on an ongoing basis, not on a transactional basis, but show us where all your scooters and all your cars are at this moment, and for all moments. And this is, I think, a very dangerous and concerning development. And oftentimes there are not proper purposes specified for needing this data. In other words, they're collecting it and trying to figure out later how to use it to make their city smarter. We think that's the wrong direction. We say you're putting the cart before the horse. You specify your purpose, your goal, and then you collect only the data that's needed to accomplish that goal. And I'll add one more thing. There are mechanisms to make the data collected less invasive, less revealing. Those mechanisms include sampling instead of collection of all data at all times in real time. They include anonymizing the last few hundred meters of a person's trip so that you don't know exactly where the person started and where the person finished. For example, there's only one human in the world who goes from my house to my office every day, except now during COVID times. And that human is me, and I'm identifiable through other mechanisms. But once you identify me, you know where I am, you know where I've gone. So I think that that data can be anonymized to some extent and still serve the goals that the cities have in collecting the data up front.
Thanks, Greg. I think that is spot on. And I think, we're talking about a lot of common sense principles and best practices for anonymizing data. But for my next question, it's diving into whether there are actually legal and policy frameworks that exist that sort of account for the risks that you all mentioned, but facilitate the exchange of data between companies and governments in a sort of streamlined but also rigorous way. And Sam, I'd love to start with you. There's a lot of scrutiny on the Chinese government when it comes to data collection and surveillance, but are there specific rules or laws regulating government access to data?
Oftentimes I hear that a meme that no data is ever confidential in China, that if the government wants it, they can get it. And they'll point to the National Intelligence Law as one example. And indeed, the National Intelligence Law basically says organizations have to comply with national security investigations. Now, this is this puts no guardrails whatsoever in place on government access to data. And so it's understandable how this, why we would point to this as an example of nothing is ever free from government interference. I think Chinese law is designed to be far-reaching and vast, specifically to provide that room for maneuverability, and is enforced in a sort of ad hoc, selective way as the government sees fit. However, it doesn't necessarily mean that it always happens. Now, we can talk about whether or not this is the right legal and policy approach. I think obviously it's not. But I think one thing that's been an interesting development to watch is in July, the Chinese government released a draft data security law. Now, not to be mistaken for the Hong Kong national security law, which I think has gotten a lot of attention here in the West. This is separate from the Hong Kong national security law. The data security law is a high-level blueprint about how the government is approaching managing data deemed vital to national security. And in particular, the article that I found one of the most interesting ones is Article 32. It says that when the government wants to access private data, it must go through certain procedures and processes according to law. Again, one of these catch-all, what the heck does this even mean? Can't they just do whatever they want? I mean, yes, they can. But in conversations that I've had with Chinese scholars who've been involved with writing and shaping this, that article was an attempt to whittle down the potentially vast scope of the national intelligence law by providing a lawful path for government access to private sector data. Now, in order for this to be meaningful, we need to understand, well, what are those specific processes? What are those relevant laws? What is the enforcement mechanism and the oversight mechanism? And so one could argue, does this just codify an existing authority for the government to have carte blanche access? And I think it could potentially could. Why would the government deliberately put in place restraints on its own ability to collect and access that private data? But it's interesting to see the way in which they've articulated in law an effort to create a lawful path to accessing it.
Thanks, Sam. And I think it's definitely a little unexpected to hear that the Chinese government is placing limitations on how they can access and use data. But I think it also comes to the point that, implementation matters. And we're seeing, how this gets done practically. Jake, I'm curious. I mean, we're seeing a super practical, super codified approach to collecting data over in the United States. And one particular standard and framework comes to mind, which was born in Los Angeles and sets forth a super kind of practical framework for facilitating data exchange. I'm wondering if you can talk a little more about the mobility data standard and some of your thoughts around that.
Yeah, sure. So for folks who don't know, the mobility data specification is originated in Los Angeles and in particular through the Los Angeles Department of Transportation. And the MDS, as we call it, specifies what mobility providers, largely, I think right now it's limited to scooters and bikes, have to provide to the government in order to have a permit to operate in Los Angeles. So in Los Angeles, if you get on a scooter, that scooter has to provide a certain amount of information to the Los Angeles Department of Transportation and to the city in order to for that scooter company to operate. And the amount of information that is required to be provided by the scooter companies is really is incredibly detailed. It is in real time, according to the specification, and it is the maximum amount of resolution from the scooter that is available. So in many cases, that's going to be the like 5 decimal places of accuracy under GPS, which I think is like in the range of it is like a meter of accuracy. So you really can tell exactly where the person is who's riding that scooter at every stage. It's not just the start and end point; it's actually the exact route that the scooter takes. And this again has to be provided in real time. And so when we think about the risks associated with a framework like that, I think they do sort of line up with everything we've been discussing already. The risks of identifying where people are going, what they're doing, their places of worship, their medical treatment, their political commitments, and their associations. And so the ACLU of Northern California and Southern California has filed a lawsuit against the LA Department of Transportation challenging the legality of that framework under the Fourth Amendment and under the California Electronic Communications Privacy Act. And I think that particular example, and I represent the plaintiffs in that case, so that's our lawsuit. I think that example does give some suggestion as to what the right legal framework is to protect information like that. And one, there's a question in the chat about how to protect information that's purchased by governments from private industry. And the ACLU has a nationwide framework for local regulation of surveillance technology. We call it the Community Control Over Police Surveillance, like CCOPS, CCOPS. And that imposes basically democratic constraints on acquisition of surveillance technology or data by governments. So before a surveillance technology can be purchased, the government has to go through a democratic process. They have to have transparency, oversight, and accountability over that acquisition. The second legal framework in California, at least, is a law called Cal-ECPA, which requires a warrant or other like really strong legal process in order to get access to that location information. So those are two possible frameworks that exist in California and other places in the United States that I think do impose really strong protections for this kind of sensitive information.
Thanks, Jake. And I'm keen to see how the lawsuit plays out and more specifically how it changes how we think about not just data sharing between companies and government, but also location data and extending what we've seen from Carpenter and other similar cases to match technology that's evolving so quickly. So shifting gears a little, I wanted to talk about trust. Trust is foundational when it comes to collecting personal data. And that's true between consumers and companies, companies and governments, and consumers and governments. But that trust needs to be earned. And Greg, I'd love to hear your thoughts on how the private sector and the public sector can work together on shrinking what I see as a pretty large trust deficit between these sectors when it comes to data sharing.
I think a trust deficit is a healthy thing. People should be skeptical, and the way to build trust is to be transparent about exactly what is happening with people's data. And it's really important because, first, people will be less likely to use a service if they don't understand how the data from that service is being used by the company that provides it. And they won't trust that service if they know the data that the company is obtaining through providing that service is given willy-nilly to the government, whether it's compelled or volunteered. And in the case of the MDS specification that Jake was talking about, it's compelled. And you, as a company, are compelled to disclose information that, in my view, Congress or the local legislature in California intended be protected. And that's why we think the litigation ACLU brought is really important. And in a way, Uttara, it builds trust, right? Because people will know, well, they're going to be skeptical. They're going to say, hey, wait a minute, all my data is going to the government. And look, ACLU sued. On the other hand, if the result of that litigation is a clarification that that data can't go to the government, or the circumstances under which it can go to the government, then all of a sudden you have an education, and you have transparency, and you have more, I think, willingness to use a service because it can be trusted, because people know where the data is going. I also wanted to follow up on the point made in the chat about the government's purchase of information. In the US, we have a strange, anomalous privacy protection that makes it so that whether data is protected depends on the nature of the entity that is providing the service. In US parlance, if the entity is an electronic communication service provider or a remote computing service provider, the data can be protected under ECPA, the Electronic Communications Privacy Act. If they're not those things, the data isn't protected. And so the situation has arisen that non-content data, such as location information, can be disclosed by a company that collects it and is covered by this statute. It can be disclosed to another company, a broker of that data, and all of a sudden it loses its protection. That seems quite wrong, and it's something that we at CDT, my organization, have been trying to address. And I've become aware of legislation in the US that will be introduced in the near future to address it. So it's a problem. We're working on it, and we'll see where it goes.
Great. Thank you, Greg. I'd love to, so, you know, we've talked about companies and the public sector, you know, using transparency, using standards in order to build more trust, but also just, you know, build more transparency to the public about what they're doing, so that it's really, you know, up to the public to determine whether that's how they want their private sector and public sector operating. Jake, I'm curious to hear your thoughts on how private companies can actually build more trust with their consumers. I think, you know, we have to always think about the data supply chain from raw collection, processing, and then ultimately sharing with third parties. How do we get better on the earlier side of that chain?
Yeah, I know. I think it's such an important question. And I think the trust deficit is very real and a real problem, and it does apply both to the private sector and to the government, to the public sector. You know, when people think about the information that's collected about them as they browse the internet, as they move about the world, as they make use of electronic services. You know, they also see that there are data breaches, you know, every month where their information is being extracted from a private company, and who knows where it's going. They also see that their information is being used for purposes that they sort of, like, number one, wouldn't approve, didn't consent to, and really couldn't fathom in this day and age. And so all of that, I think, does create the trust deficit, and I think that the standards really do need to sort of be the same for private industry versus the government. When an entity wants to collect information, there should be a purpose that is identified at the outset. That purpose should be you know, very concrete and very specific. And then the information that's collected in order to fulfill that purpose really shouldn't be used for anything other than that purpose. You know, we do have some hints of that kind of limitation on the private collection and exploitation of information starting to emerge in the privacy laws in the United States. The CCPA has some version of a purpose limitation built into it. The CCPA is the California Consumer Privacy Act. But the specification of those purposes is very general. And so it still doesn't allow people to have a real concrete understanding of how their information is used. And so I think, and then the second piece and of that trust is the ability for people to vindicate their rights when they're violated. And I think that means a private right of action. It means that if someone feels that purpose specification has been violated, they can go to court and say, my rights have been violated, and I want to, number one, stop the conduct that's unlawful from happening, and number two, have some kind of compensation as a result of that violation of rights. And that private right of action piece, where people actually have a place to go when their rights are violated, instead of just hoping that a government regulator, for example, will do something, I think is an important part of it. And that over a long period of time, I think will build more trust, because there's a remedy if that trust is violated.
I completely agree. And I think there's a lot of opportunity and a lot of room to get better. And, we're seeing that live. We're seeing that with the large tech hearing that happened yesterday. People are demanding more transparency, and it'll happen. So changing gears a bit, I want to talk about public policy and location data. So I am convinced, personally and after working at Uber, that mobility and location data in certain forms can be incredibly useful for a variety of policy applications. But I also know that the transportation sector has historical biases that are ingrained in the geography, that are ingrained in neighborhoods. We also know that lower income areas tend to be surveilled more, which is a high price to pay even for great policy. Paola, I'd love to get your thoughts on using mobility data and how to use data on where people are going and where they're starting their trips and where they're ending their trips, without exacerbating existing socioeconomic disparities.
Sure, Uttara. Yes, I completely agree with you. I believe that the use of location data and technological developments such as artificial intelligence do offer opportunities for policymakers to gain new insights and respond better to the planning, delivery, and management of mobility services, as well as transport infrastructure, benefiting developing communities for sure. Though we should bear in mind that disparities in mobile phone use, digital literacy, and tech uptake could exclude underserved communities or marginalized populations from the regulatory impact analysis that all governments must do. As an example, 30% of the Peruvian population do not have a mobile phone. In the US, 2019 Pew survey found that only 68% of older people between ages 55 to 73 own smartphones, compared to 93% of millennials. Also, let's not forget that according to the ACLU, women are up to 31% less likely to have internet access than men in some countries. Therefore, the use of incomplete and discriminatory data sets can misdirect the government efforts in ways that jeopardize the rights of the most vulnerable people. The tension here is that policymakers want to serve the underserved, but to do it, they tend to use more surveillance tech. We know the government wants the cities to be safer, be less congested, to improve the quality of the air, etc. However, we should keep in mind that data and the collection of data should be a means to an end, as Greg and Jake mentioned earlier. So in the first place, government need to ask themselves what data they need from a city perspective, plus in terms of the expected outcome. This question is not being asked anymore. Some authorities believe they need all the data that is available, and afterwards will do the evaluation. That is where we get to situations, indeed, that all cities are asking for too much data without even thinking about what they might need it for. Instead, policymakers, I believe, must work to protect against potential harms of data analysis. A growing body of research shows that without careful considerations, this sort of collection can work against the people policymakers intend to help, and this is completely the opposite desired outcome. Then I suggest that improving stakeholder participation to identify policy opportunities alongside the public sector can help avoid exacerbating existing socioeconomic disparities through data-driven policymaking. In other words, we need to start bringing more voices to the table. For instance, civil society, academics, the industry, and community-based organizations. So this must be taken into account, and I think that's one step to a better policymaking.
Thanks, Paola. I think that's spot on, and makes so much sense. But as we're moving forward, I think a key question in my mind is who's actually accountable for measuring and then addressing bias? How do we make sure we're actually moving forward and improving the way we treat each other and treat the communities we serve? Jake, would love to get your thoughts on that.
Yeah. So, I think there's two, to make one sort of framing point. We talk about how new technologies can be deployed in a way that doesn't exacerbate existing economic, racial biases. But I do think that we should think about that. It's important. But also, when new technologies come into play, there's the risk of exacerbating current biases. But then there's also an opportunity to undermine those current biases. And I think of Angela Davis's phrase of being an anti-racist. And so I think that the goal of deployment of new technology should be actually to undermine and to destroy existing biases that exist in society. And so that's a sort of a framing point that I think we should raise the level of our ambition with respect to the good that can come from a transformative moment when technology is deployed. And with respect to how that measurement happens, I do think that there's a role for government in determining what the right framework is for deploying a technology. I've talked a lot today about the harm of information in the hands of government, but when it comes to, for example, making sure that new mobility modes are deployed in a way that is not just putting a whole bunch of scooters in a rich neighborhood and having poor neighborhoods deprived of new ways of getting to work, for example. That's an important role. I think it's a role that is sort of vitally served by government, and there does need to be some kind of information transferred to government in order for that to happen. That transfer, though, needs to be subject to the purpose specifications that Greg and Paola have talked about, and the limitation on what information is provided needs to be limited to that purpose. And so some of the technologies or the solutions that Greg mentioned, aggregation, and can be used to make sure that purpose specification is limited. And using those tools, I do think that there is a way to undermine existing biases, discrimination in society, and so it's a promising area.
So just to follow up on that, if I could, so say the problem is that taxi cabs aren't serving poor neighborhoods, and that's an existing problem in a lot of countries. Uber comes in, and Uber starts serving people who need rides, and the government wants to know, is Uber addressing the problem, or are they making it worse? So the government wants to know, where are the Uber cars going? Are they going into the underserved neighborhoods? So it wants to collect that data. What should it do? How could it do that in a privacy protective way? One mechanism would be not to collect that data all the time in real time. They don't really need it to serve the anti-discrimination purpose. They could use stored data. Do they need stored data over, do they need individualized stored data? Well, they don't really need to know that the car went to a particular address. They just need to know whether it went to a neighborhood or not. So it can be anonymized. The data can be anonymized in that way by excluding that last 500 meters or so that you don't have individually identifiable data. Do you really need 90 days of data all the time? No, you really don't. You could sample and just use some snapshots to see whether the Ubers were serving the underserved neighborhood. And with that privacy protective, anti-discrimination purpose and data serving that purpose, you could issue a regulation that would further your anti-discrimination purpose. So I think that there are good uses for this data, and I think that the good uses can be to further non-discrimination purposes, and that you don't have to violate people's privacy to accomplish those goals.
Greg, I couldn't agree more. I think, for Uber, we've worked with cities to define zones of particular interest to cities when it comes to equity and accessibility. knowing whether those zones are being properly served by Uber is incredibly important. It's an important question, and we should be working harder to serve more cities that are investigating those kinds of issues. Alrighty, I have one more question before we wrap up, and it's about coronavirus, which I think we'd be remiss not to talk about, given all the privacy concerns that have sort of been raised to the fore. For me, I think it's amazing to see that even in the midst of a pandemic, a global pandemic, people are asking really important questions about what data and location tracking can practically solve, and whether the risk of data misuse outweighs the potential and hypothetical benefits of using this data. Sam, I'm very curious to hear from you about how China has handled this and how the public is responding. Specifically, do you think that there's a tide shifting in how the public is starting to tolerate surveillance?
The Chinese government very swiftly turned the same censorship and surveillance tools that had been used to suppress and censor information about COVID in the early days. It very swiftly turned those into developing and swiftly deploying a vast contact tracing system, which is known as the Health Code program. And what this was is it actually wasn't one single program, but multiple different municipalities and regions, the local and city governments worked with different tech platforms, so Alibaba and WeChat as some of the larger ones, but there were others, to collaboratively build a tool in which people would opt in. It was consent driven, but we can talk about whether it was in practice actually voluntary. And they would answer a question about where they had been, who they'd been in contact with, and then on their smartphone, a QR code, they would scan this QR code, and in order to get access to riding the train, getting into certain bars and restaurants as the economy began to reopen, they would need to have a green signal, and the red signal would say that they were at risk and had to quarantine. So one of the questions that has come up around this is, this was widely used, and I think one of the reasons that the Chinese government was able to sort of very quickly figure out, how to, if someone was on a train with an infected passenger, that information was combined with health information, with payments data, with ride-sharing data, and get a really granular picture, which could be part of identification and containment of the spread of the virus. One of the risks, of course, which has been highlighted, is after the use for the pandemic had passed, what would the government continue to do with all of that data, and would they continue to use that in ways that would be really problematic? So, for example, the Hangzhou government floated the idea of having a health index where this information would continue to live on and be used to rate people for other reasons, a form of sort of algorithmic governance beyond public health purposes. Again, I think something that's sort of missing from the discussion of these issues outside of China is there has been a lot of debate inside China about it. So after the Hangzhou government announced that they were looking to extend this into a sort of myriad number of uses beyond the pandemic, there again was this outcry on Chinese social media, and at least the Hangzhou program was shut down, which was interesting to see. The Cyberspace Administration of China, one of the most sort of powerful regulators in the cyber realm in China, issued notices about how to use these tools but limit their purpose to public health. But again, this is all happening in a system, I think, which lacks rule of law and oversight and some of the other sort of important, strong legal frameworks that have been discussed on this panel. So the question is, how meaningful is this going to be in practice? But I think it is important to understand that at least some of those debates have been taking place.
Great, thanks, Sam. That it's always very interesting to see. We think that there's a vast difference between how these different countries are tackling this issue, but this is such a interesting natural experiment that's going on to see how governments and companies and individuals respond to COVID. And I have no doubt that there will be so many history books about the time we're living in right now, and a lot of comparisons between different economies and different markets. Greg, you founded a task force to examine the various risks associated with using data to contain the spread of COVID in the United States. Can you share any important insights that you've gained thus far? Is this an opportunity to sort of fundamentally change the way in which governments can access user data?
We founded this task force early on in the pandemic, the Data for Life and Liberty Task Force. And it involves companies, civil society groups, health professionals, lawyers, and academics and technologists. And we come together to look at the tough issues. When we first started, it looked like the United States was going to go down a very draconian road and issue and perhaps come up with a new law that would require people to have information like their location disclosed to governmental entities on an ongoing basis. It hasn't panned out like that. We can't even get people to wear masks. And there's really very little enforcement in the United States. So what the task force did initially was issue some general guidance about the use of data in COVID-19. And now we're turning to particular issues. We'll have a paper shortly on equity issues in contact tracing. And contact tracing is the art of getting people who have been exposed to others who have coronavirus tested or quarantined. And it really is an art, it's a difficult thing. We're looking for other areas where we might be able to be helpful. But I will say this, in coronavirus, the lack of enforcement was a surprise to me. I thought we were facing a much more draconian and difficult scenario from a civil liberties perspective. There's been some enforcement, but not so much.
Thanks, Greg. Clearly, we will wait to continue to see how this all plays out. But I want to open up Q&A from the audience. I see we have quite a few great questions. I will use my moderator's privilege to choose my favorite ones. So let's see. I think we have one for Sam, I believe. It asks, is there an obligation of transparency in the cybersecurity law in China? In some GDPR type laws, this involves making sure the data given is easily readable. Sam, would you mind taking that one?
So the cybersecurity law is very high level, broad principles. And my understanding, I'd have to go back and read it, is it does not. However, there's a follow-on specification called the Personal Information Security Specification, which is a voluntary standard. And it was meant to sort of spell out the details related to consent and processing and sharing of data. It was actually modeled on GDPR, meant to be a sort of GDPR with Chinese characteristics. And I would have to go back and look, but that's a great question. And I would go and look. My colleagues and I at New America actually translated that specification. So I point you to our DigiChina website, where we have translations of a lot of Chinese law and policy focused on the digital economy. So I point you to that specification. And I myself am interested and will go back and read it to see if that exists there.
Perfect. Thank you. The next one I see is curious how Sam's reading of the flouting of data handover plays into the general trend of transportation network companies also ignoring local public utility commissions and city regulations on fare rates and licensing. Is this generally feeling above the law, or is it a good faith stand for users in your reading? I think it's a fair question. I would say that
you go ahead and answer it. Go take that one. I'm going to do this one thing. I don't know.
I'll take this one. Look, I joined Uber about 2 years ago, and I think at that point, Uber had learned a very, very important and hard lesson that it is not above the law, and we are sort of inextricably linked with the public right of way, and we need to work with cities in order to get things done. So I would say that that's been an enormously important lesson. I don't think that flouting necessarily is the right word, but if the question is about whether this is actually about privacy, it absolutely is. I think it would be far easier for Uber to just reveal and transfer user data when asked without question than actually spend time trying to change those requests, trying to narrow them, trying to transform the data to protect privacy. And for the past 2 years that I've been here, that's been consistent in every data request. It's never a question of whether we'll share data. It's actually the much harder question of how we'll share data and how we can do that in order to protect privacy. So I hope that answers your question. The next question is about the US government purchasing data, but Greg, I think you already addressed that. So I'll go to, let's see, Vipul's question. What is the panel's perspective on data ownership? Who owns the data and how can individuals exercise and control their data while big tech platforms exploit and monetize this data? I will open this up to the panel. Who has thoughts on this one?
I would put it this way. Even if the companies own the data, the consumers have an interest in how that data is secured, how that data is disclosed, and ought to have a legal right to have those interests protected. That's how I would respond to that.
I would just add one quick point about the concept of data ownership. I do think that sometimes the notion of people owning their own data or having some sort of concept of privacy rights around or sort of property rights in information about them is often a mechanism for that information to be captured by industry and to be exploited by industry without really very many limitations. Fundamentally, if you have a situation where people just are where their information can be collected and then it's then becomes the property of whoever has collected it, that is going to disproportionately harm people who are poor and who can't afford to either not sell or to buy back their information from an entity, whether it's a company or the government who has collected it. And so the notion of creating privacy laws that build on a core concept of data as property, I think has problematic consequences, and we really should be avoiding it. The framework, I think, is a human rights framework that we should be using for thinking about privacy rights rather than a property framework.
Just to add on real quick, I think there's also an important international component to data ownership. And I know others on the panel work on cross-border data transfers in this context. There's an important sort of debate about data sovereignty, and is the ownership of data something that transcends geographical borders? Does this exist within a company regardless of where the data is stored? Or is this something that maps onto national sovereignty? And particularly, I think in the US-China relationship right now, we're seeing an important debate play out around this, where traditionally the Chinese government's position has been data ownership maps onto national sovereignty. So even if, say, Microsoft China holds Chinese citizen data in China, that's Chinese citizen data that wouldn't be subject to US law enforcement requests of Microsoft, even if Microsoft had custody and control of that data, for example. I think in the US, we're beginning to see a bit of a shift and more of a national sovereign approach to data ownership in the US. This is playing out, I think, in this sort of TikTok controversy. Should US citizen data held by overseas companies need to stay stored on servers in the US or be prohibited from being transferred to what's deemed a foreign adversary country? So important to sort of watch how I think geopolitics is playing out in this question of data ownership and national borders.
Thanks so much. And I believe we're at time. I'm sorry I couldn't get to all the questions. Thanks so much to everyone who is on the live stream for joining us. A huge thank you to the panelists for lending their considerable expertise here. I have no doubt that this is going to be a key issue for this generation and generations to come. And my hope is that we can continue to bring new voices and new perspectives into the fold at conferences like this one. Thanks, everyone.